Hi, and welcome back to the channel. My name is Attorney Stanley Valinsky. I am a lawyer in Massachusetts. I have been practicing law for about 25 years now, just about have it right. And I'm here today to talk about grandparent visitation. This is a topic that comes up quite frequently in my practice. It is a fairly new statute. It's been around for some years, but it's very, very misunderstood. General Laws Chapter 119, Section 39D creates a right for grandparents to petition the probate and family court for parenting time with their grandchild. So I'm making this video to try to help those who either have brought these petitions or even have had these petitions brought against them to know the law, your rights, and the likelihood of succeeding in one of these causes of action. So one of the things that I teach younger lawyers is that you should always read the rule or the statute or the law. You know, a lot of times we go by word of mouth or otherwise. A good lawyer always reads the rule. So General Laws Chapter 119, Section 39D, which is the statute that creates this rights in grandparents, says that if parents of an unmarried minor child are divorced, married, living apart under a temporary order or judgment of separate support, or if either or both parents are deceased, or if said unmarried child was born out of wedlock, whose paternity has been adjudicated by a court of competent jurisdiction, or whose father has signed an acknowledgement of paternity, and the parents do not reside together, the grandparents of such minor child may be granted reasonable visitation rights. Now, holy cow. Why would you have me read a statute when it's worded like that? Statutes are the craziest wording. If you want to not understand something, read the statute. But that's why you pay lawyers to read statutes and to understand them. What all this means is, now why I read that statute to you, why I'm telling you that statute, is because number one, and I'm going to explain this statute and this petition relates to a very minor percentage of people, those that I read under temporary orders, married, living apart, so forth. You need to fall into one of those categories before you can even think about having one of these petitions. So what leads to these kind of lawsuits involves parents who've separated or divorced that have young children. Due to one parent or the other, either or both sets of grandparents are no longer seeing their children. So the scenarios are very limited. Perhaps one set of grandparents are no longer alive, and the children are mostly with a parent who no longer has grandparents who are living. The living grandparents are those of the parent who may not have custody of the children or lost custody of the children, is him or herself deceased, or maybe doesn't get along with the other parent. So grandparents, as they allege, they're no longer able to see their grandchildren. That's when these suits arise. This is partially what the law was meant to address. Now, the law does not and is not intended to allow every grandparent to bring an action and expect the courts to grant parenting time. The leading case that discusses this in significant detail, it's a leading case in the area, is called Blixt versus Blixt, which is B-L-I-X-T, 437 Mass 665. It's a 2002 decision. As the Supreme Court stated in their opinion in Blixt, there are certain predicates or pre-existing factors that must be in place before you would even consider bringing one of these causes of action. First, the law itself ran into a serious constitutional problem. Raising your child is a constitutional right in the United States of America. If a parent is fit, they are presumed to be acting in the best interest of their child. So, telling a fit parent how to raise their child, if they decide that he or she does not want their child around the grandparents, is the parent's right as a fit parent to make. So this Blixt case balanced the need for the grandparents to be in the child's life and the rights of a fit parent to make decisions about their kid that they're constitutionally allowed to do. So now, if I use the word visitation, it's because it's what's used in the law. It's a terrible word. Children aren't prisoners. You know, the word visitation implies some type of inmate situation. It's a terrible word. It should be called parenting time. So the way the courts resolved this issue of the courts overruling a fit parent are extremely narrow. The entire law is based on the need to avoid harm to a child. So let me repeat that because it's really important, and it's an absolute requirement before you can even file one of these lawsuits. In other words, when you file one of these petitions, you need to have an affidavit attached to that petition stating what the specific harm is, if the petition were not allowed, or the case will be dismissed. So the very first thing that must be shown is that the failure of this particular child or children to see this particular grandparent at this time is necessary to avoid this specialized harm to that specific child or children. I mean, it's a mouthful. So you, the grandparent, the petitioner, have to allege that the grandchild is going to suffer some kind of harm if they stop seeing you, or if they're not forced to see you, against the parent's wishes, obviously. One of the things you may have noticed when I read part of that statute is that the law is specifically designed for parents who have separated or are no longer together. So if you've got two married parents, the grandparents can't just bring a petition to see their grandkids. That'll be dismissed right away. In order to show the harm, the grandparents must show a number of things. First, that the fit parents planted the grandparent in the child's life before the decision was made to separate the child from the grandparent. So what does that mean? It means that the parent had made a decision at some prior point before they stopped letting the grandchild see the grandparent or parents, that they wanted the child to be in the grandparent's life, and vice versa. The grandparent wanted to be in the child's life. That's an initial showing. You can't move forward without that first showing. If the two meaning the grandparents and the grandchild never had a relationship before this petition was filed, you're going to lose. Not what the statute allows. So, in a sense, what the court is saying and what the law is saying is that the parent, the fit parent, had used the grandparent as a sort of a crutch for the child, as a replacement for the other parent. So the grandparent served as a crutch. The grandparent must first show that the fit parent first intentionally placed the grandparent in the child's life, and the presence of that grandparent was intended to serve as a type of crutch for raising that child. It was essentially a substitute for that missing parent. So if the grandparent had never before been a crucial part in the child's life, you can't use a statute. Second, the grandparent must show that the child, through the absence of the grandparent who has served as a crutch in the child's life before, will be caused a specialized harm by the absence of the grandparent. By the fit parent removing the grandparent from the child's life, the courts will be able to intervene and essentially overrule the fit parent by restoring the relationship between the grandparent and the grandchild that the child relied on and needed. So this largely misunderstood law requires a grandparent to show that he or she had been deliberately placed into a child's life, and that the removal of the grandparent from the child's life will cause that child an individualized harm. That's it. Otherwise, the courts will generally not step in and overrule a fit parent's decision to exclude a grandparent from their child's life. As emotionally painful as that may be as a grandparent, and as crappy as that may be, that's the law. From those opposing one of these grandparent petitions, say you're a fit parent and you've made the decision that you don't believe that a relationship with your child's grandparents is healthy, and maybe something happened, and made the decision that you were going to stop having them see each other. Generally speaking, the courts aren't going to step in unless the separation of those two, and a lot of times this is based on expert testimony, that the separation of the two will cause the child harm, that you've taken away a crutch that the child needs, essentially. So as with anything law related, the law is complex, every case is different. You should consult with a lawyer. Please don't take this as a case analysis. This is a general description of grandparent visitation law. You should always get a lawyer's advice whenever family is involved, whenever the court's involved. The last thing in the world that you want to do is leave the decisions that relate to your family up to the state, the court. The courts don't want to do that either. So I hope this video gave you some helpful information about grandparents, visitation rights or rights, parenting rights, however you want to call it, in general laws, chapter 119, 39D. Please note that this discussion is very different from those of guardianships or conservatorships. That's an entirely different issue. And there are other ways that grandparents may end up having custody or parenting time or some type of court involvement in a child's life or their grandchild's life. So this statute is different from all of that. That's an entirely different area of the law than 11939D. So thanks for watching. Subscribe to this channel if this content is useful to you. I am going to be posting regular, hopefully useful, issues that come up in my practice all the time, where people come to me and don't really have the first idea of where to even begin, or whether they have rights or whether they should do something. I'm trying to get out content that relates to that the most. So because I like to help people, and I've been doing this for a long time, and I think YouTube's great for these kind of things. So YouTube's great for just about anything, even when building a car, I guess. But please subscribe if I'm trying to grow the channel. I'm trying to get this information out, so it does help if you subscribe and interact with the channel somehow, thumbs up or whatever, everybody tells you to do. So please feel free to tell me in the comments whether you've considered bringing one of these petitions before, whether you've been served with one of these petitions. They become, at least in Massachusetts, they've become increasingly frequent. I see them quite often now, largely because I think it's misunderstood. I think that grandparents have seen the statute or they've heard about it, and they just believe that there's an ability for any grandparent in the world to get grandparents rights. It's very limited, folks. It doesn't mean it can't happen. It definitely can. You just need to make a good enough argument, and you need to have the facts to support it. So thank you very much. Until the next one, have a good day.